Good afternoon. Welcome to the First District Court of Appeal at the Bradford County Courthouse. Thank you for having us here. We have three cases on the docket. The first one is Carly A. Volpe versus the Florida Sheriff Risk Management Fund. You have 15 minutes per side. Counsel, are you ready to proceed?
I'm ready, Your Honor.
Okay, then proceed.
May it please the court, Your Honors, this appeal asks the court to decide de novo whether a coverage agreement issued to the Nassau County Sheriff by the Florida Sheriff's Risk Management Fund can expressly cover battery while denying coverage for any criminal act. Even if this court affirms the circuit court decision, the court will still have to explain how the express coverage of battery harmonizes with the exclusion of all criminal acts. That or remand the case for an explanation from the circuit court. This is the same ambiguity that the 5th DCA recognized. Sir?
Why?
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 Why? Why must
Even if we
there be-
affirm, why are we required to provide this explanation you're talking about?
Well, for the law to understand, in order for the law
So
to
you would
understand-
like us to,
I
because
would very much like
it
to.
would help counsel out there in similar situations.
It would help everybody
Okay.
else, yes, sir. Yes. Now, it is the same ambiguity that the 5th DCA recognized in its 1997 case of Mason against the fund's predecessor. The 5th DCA correctly recognized there that there is simply no way to reconcile the conflict between these provisions. The 5th DCA allowed the exclusion there in Mason, but only because the man in the street understanding of battery does not include sexual battery.
So we're talking about a coverage contract, right?
We are talking about a coverage contract, yes, sir.
Ms. Volpe is not a party to this contract.
She is not.
So how does she have standing to seek declaratory relief?
Well,
about
Your
the
Honor,
contract?
I think that the appellee has abandoned or is not standing on that any longer. We filed the case, and but for the one statute that says that liability, that a plaintiff in a case would not have.
Well, normally a plaintiff sues a defendant
Correct.
who is either negligent or liable in tort, either intentional or negligent tort, right?
Yes, sir.
And the person who's being sued says, insurance company, you got to represent me, and you got to defend me, and you might have to cover damages. That's not happening here.
Well, for the procedural status of this case, though, Your Honor, standing is not jurisdictional. In that sense, and I don't have the case on the
Sure.
tip of it, it's not jurisdictional, but.
I believe that standing is not jurisdictional.
But the point
yeah.
that point has been waived. I mean, that point has been conceded by the appellee.
But we can
that they need to-
but we can affirm for any reason, even if it's not raised by the appellee. And I think, and I have the same question. So your client sued for declaratory judgment. And I think
correct.
part of the question is well, what interest or right of your client is she seeking to clarify?
Your Honor, the discussion was held in the federal court, the district court in the underlying federal case in this case. The discussion was held there that whether or not Mr. Sassa had coverage would be useful towards the resolution of the issue, possible settlement in the case underlying, if we could determine about Mr. Sassa's coverage. And the fund represented Sheriff Leeper. Sheriff Leeper agreed with that in the underlying case, and the fund was represented. And the fund has the right to control the defense and control the representations that Mr. Sassa, that Sheriff Leeper would have been making. And in that case underlying, the fund itself said we have an interest in seeing the question of coverage decided. Now, they didn't file a suit, so somebody had to file a suit. Mr. Sassa has representation of pro bono. Mr. Metter, I think is his
Right,
name.
but it's not the circuit court's job to act as an adjunct for the federal court. I mean, if the federal court is interested, that's up to the federal court. If someone's interested, that's one thing. But circuit courts are there to actually adjudicate rights and interests, and the Declaratory Judgment Act exists to allow that to happen if there's a right or interest in place. And the case that your client cited in the second amended complaint was abrogated by what is currently 6274136, which I think you acknowledged.
which specifically applies to liability insurance and.
Well, then the Supreme Court said later it's all kinds of other insurance as well.
Well, but in this particular case, the defendant or the appellee here has taken the position that it is not an insurance, that the fund is not an insurer, and that the coverage agreement is not insurance.
Okay, but then that
so-
eliminates the original case that you relied on, the Second Amendment complaint, which was based on insurance. So if it's not insurance, then you definitely don't have an interest in the case. You can't even rely on the Supreme Court.
Well, it would still be a contract, and it would
That
be.
you're not a third-party beneficiary to. Because the only reason that you'd be a third-party beneficiary is because the Supreme Court said so in the 1960s.
We are a third-party beneficiary to that contract, and the only reason we don't have standing, or the only reason we would not be accorded that, is because of the statute, passed in derogation of the common law,
No,
which should be strictly.
It was passed in derogation of what the Supreme Court said, and the Supreme Court was looking at insurance law based on an insurance policy, and it said that an insured or a third party, the injured is a third party beneficiary of that insurance contract. But if you're saying, well, 6274136 doesn't apply because it's not insurance, well, then neither does the Supreme Court decision saying that your client's a third party beneficiary.
But that would be if it's an insurance contract.
Right.
That
which you
would
said
be if
it's
it's
not.
an insurance contract, but if it is not an insurance contract, it is still a contract. It is still a contract, and that statute applies to, and the Supreme Court's decision applies to insurance.
Which you say it's not.
Well, I say it is insurance, but they say it's not. And I will say too, Your Honor, that this issue had been addressed before the circuit court. It was not ruled on by the circuit court. The circuit court didn't use that issue, didn't use that as a prong to say that we didn't have standing and that it wasn't going to hear it.
Well, let's get to the contract. So you have an insurance contract that says covered members are covered for battery.
Correct.
So that seems to cover this, right?
It would seem to cover this.
But then
yes.
another place in the contract, it says covered members are not covered for criminal acts.
That's correct.
So how do you propose we reconcile all that?
Well, Your Honor, that is illusory coverage. It is illusory coverage as to Mr. Sasser, and just as the 5th DCA would have decided in the Mason case, it would have said there's absolutely no way to reconcile these. There's no way to understand what that. There's no way to know what battery means in the coverages section of this contract.
Counsel, assuming we get through the prerequisite of a DEC action, there has to be a right at interest, and then we look at this contract interpretation question. The briefs make a lot about whether this is traditional insurance coverage or self-insurance. What impact, if any, does that have on contract interpretation principles that we are all familiar with?
Well, if I'm understanding you, Your Honor, the impact that it does have is that where there is an ambiguity of this sort, where there is a conflict between these provisions that renders coverage, that swallows up coverage as it does for Mr. Sasser in this case, that should be construed against the drafter of the contract, and the drafter of this contract is the fund. Now, the argument has been made that this is self-insurance, but it's not self-insurance. Let me find where it's not self-insurance because the section 163.1 permits the Florida sheriffs to join together as self-insurers to form risk pools. And the fund is that. It's a risk pool. It is a separate legal person. It is a risk pool. It does exactly what in Appleman, where they said traditional insurance involves risk shifting. Self-insurance involves risk retention. And risk shifting is exactly what the fund is about. It is a risk management pool that shifts the risk of its member sheriffs into this common pool. So it is, and again.
Well, they would argue that it's not risk shifting, it's risk sharing. And is there any difference between the two?
I think that there's no difference between the two. I think they're the same thing. I mean, risk sharing takes the burden, risk sharing as opposed to shifting, would take the burden of being out there on his own, defending his cases. It would take the burden of being out there on his own.
And that's kind of the
and
model of the old mutual insurance funds, right?
Yes, sir.
Okay.
Yes, sir. Okay. No. I would like to say, I want to say further, if the fund has argued that the coverage agreement is a non-insurance contract, that's just not what the coverage agreement is. It is not a non-insurance contract. It is an insurance contract, even if it is not issued by a traditional commercial insurer. It's not a non-insurance contract. It is a contract of indemnity. That's the purpose of the contract, is to indemnify the sheriffs or to indemnify the covered members against the liability that they face. And the I'm sorry, y'all working pretty good today, huh?
We do that sometimes.
Yeah.
Let me ask you real quick, did you want to save some time for rebuttal? I don't know if you said when you started.
I would like to save what I have left if I could. I mean,
You may do that if you would like.
I think I will.
All right, thank
Your
you.
Honor.
May I proceed?
Yes.
May it please the court, John Russell on behalf of the Florida Sheriff's Risk Management Fund. What we have today is whether or not the issue is whether or not the trial court correctly interpreted and applied the coverage agreement between the sheriff's fund and its member sheriffs.
Well, counsel, before you dive in, would you start where we began with the questioning of opposing counsel as to whether this is an appropriate deck action to begin with?
Your Honor, when we got on the case, I actually had the same issues in terms of the action by a third party who has no interest in the policy or trust agreement. That has a standing issue. So what we did to remedy it was we filed a counterclaim. The counterclaim is against Sasser, who are the relevant parties to the dispute, and then we joined them as basically a co-defendant on that action. So that was a correct procedural method to have this determined, in which case their lack of standing in their own action could be remedied in the court, and the case can be proceeded on that.
So y'all went along with that?
Yeah, so we're fine in terms of having the court decide. We do believe that this issue is appropriately before the court, but on our counterclaim, not on ours. We weren't waiving our
Right, on your
right to be sued on.
counterclaim, but you didn't bring the appeal. Right, so,
No, I mean, I'm assuming he's appealed, assuming the appellant's appealed both the order granting our summary judgment as well as the order denying theirs. But yes, we cured that procedural and standing issue. We think by doing the counterclaim, which included them, so that they could be bound by the determination. Deputy Sasser did not respond or participate in any way in the underlying litigation, so they are the only parties who are proceeding forward. So yes, we did have the same issue with concerns of standing and the ability for them to bring the action in the first case. That's why we brought the counterclaim in an effort to try and cure that issue.
But I don't understand, so I understand how Sasser could be a proper defendant or cross-defendant, because that's the person who stands to lose, at least in the short term, on the determination on duty to defend. What effect, and I would ask this of opposing counsel as well, what effect does this judgment have, one way or the other, with respect to Ms. Volt right now?
It'll obviously be binding, and I guess there would be a question.
Binding on what, for what purpose?
Should there be a future judgment or settlement against Deputy Sasser and their attempts to collect against the fund?
Sure, but doesn't that make it, at this point, unless you're acknowledging that she has an interest in the fund now, even before there's a judgment against anyone on damages, how is that not just an advisory determination from the trial court, vis-a-vis, not with respect to Sasser, which seems to have been appropriate to have that determination. Now you know you're not going to get a bad faith claim for not defending him in federal court, but how does it have any effect whatsoever with respect to Volt at this point, when there hasn't been anything that's happened in the federal court?
Yeah, and obviously there's an issue between whether we think this is insurance versus self-insurance and those issues. But in the insurance context, what you would normally do is you would bring in the claimants as well in order to have a binding effect, because Florida courts have held that if you don't bind them to the judgment, then they can subsequently appeal and have a whole new coverage argument. And so what's been established essentially is that even where the insured has defaulted or failed to participate, the claimants are generally allowed to participate in moving forward. Now, I acknowledge there is an issue here in the sense that he has been defaulted and there is no judgment or settlement at that point, but in terms of that issue, it'd be a little more tricky. But like I said, we were trying to bind them to this issue and
Well, yeah,
make
so
sure that we're
you wanted
done.
you wanted an advanced determination from the trial court, advisory, before any of this happened. And now you want the same thing from us. You say, hey, we just want to know what the answers are.
Well, Your Honor, no, one of the issues that was obviously addressed is the duty to defend. And the duty to defend is at issue from the inception.
Sure. It's just not at issue in this appeal because Sasser hasn't taken an appeal.
True, and technically, they have no interest in his being defended in the
Exactly.
underlying action. But
And right now, they have no interest or judgment against him because they haven't proceeded to trial or gotten a judgment with respect to damages. And it just sounds like this whole thing started because the federal court wants to have this thing resolved by settlement. And it would be very helpful to know whether the insurance company is going to be involved in this.
yeah, well,
So then they send it to the trial court, hey, you all figure it out and tell us what the answer is. And now you're here.
as I said, I was just employed to address these issues and follow and create the procedural setup for us to address these issues. And I understand Your Honor's concern. Again, the issue of insurance versus self-insurance, a lot of that's just kind of distraction from the main issue in this case. Let's say this court says, oh, this is insurance. We're going to treat it just like insurance. And we're going to pretend that the Mason case is relevant. What we're arguing here is the language in this agreement. And this agreement is substantially different from that addressed in Mason. So Mason's not only dicta, it's dicta on language that is not relevant to this case. Because the entire argument of rules of construction and whether or not you're self-insured or insured is only relevant if the court finds an ambiguity. And the ambiguity has to exist under substantial amount of case law in that the exclusion has to entirely swallow the coverage grant. And what you have not heard from the appellant today or in any other briefing or even the underlying case is addressing the fact that the exclusion says there is no coverage for the criminal battery for the individual guilty of the criminal act. But it provides coverage for the sheriff for any liability that the sheriff faces as a result of that. So it covers the sheriffs, it doesn't cover the criminal actor. That is not ambiguous, it's clear, and it's demonstrating the intent of the fund to say, here's what we want to cover, here's what we don't. So since there is no ambiguity, there is no swallowing of the coverage, they don't even get
It
to
says they'll
that.
pay on behalf all sums, which any covered member, which is not just the sheriff. And it has a list of false arrest, assault, battery. This is a battery case. Says, read that paragraph and say, covered, right?
That's the starting point, that's the coverage
Okay.
agreement.
And then you read this other paragraph, which excludes criminal acts, and you say not covered. Well, battery's both a crime and a tort, so what do we do with that?
Again, Your Honor, you are being provided coverage to the sheriff for criminal acts of Sasser. You're just not providing coverage to the individual actually guilty of it. In fact, if
But
the sheriff...
Sasser's a covered member, right?
Absolutely, but again, a coverage agreement provides coverage. It is the grant of coverage. Exclusions always take away from that. And the exclusion here takes away coverage for certain people if they are guilty of it, but not for others. And so you could have said, okay, let's put it in the insuring agreement and say, okay, we're only gonna provide coverage for these acts for the individuals liable vicariously for them. Again, some of these are actual crimes and some are not. So the coverage agreement is a broad statement of here's what's provided. The exclusion then says here's what's not provided. And what courts have always held is that illusory coverage only exists where there is no coverage. You give it here and you take it away here. Not for some people or not for some subsets of claims, but for everything. And the 11th Circuit summarized it very clearly. Coverage is illusory only under Florida law if the insurance policy grants coverage with one hand and then completely takes it away the entirety of the same coverage. Completeness is the key. A policy is illusory only if there's an internal contradiction that completely negates coverage it expresses to provide. Here, the sheriff is getting coverage. Exclusions do not render coverage illusory, even if they make coverage dependent on extraordinary circumstances that are unlikely to occur. Here, the sheriff is getting coverage. In fact, in this case, the sheriff has been sued. The fund is defending the sheriff in this case for the criminal acts of Sasser. So you clearly have an expression of intent by the fund, by the sheriffs. By the way, the board of managers of the fund are member sheriffs. This is what they want. And another point, deputies might be sued, and they might be sued for criminal acts. That doesn't mean the fund is going to necessarily automatically say no coverage, we're not defending you. The fund can use its discretion, and it often will. It'll defend a deputy until the point in time when it makes the determination that the exclusion and the facts of the case demonstrate they should not provide coverage. That is their discretion. That's what they want. And that's what they provide within the context of the agreement. Not only do we have the coverage agreement and the exclusion at issue, the agreement itself sets forth that if there is a coverage dispute, it is the board that makes the determination. And there's a process for challenging it. And that's the way they wanted it, because they want to make sure that they're only providing the coverage and benefits that they and their members want, and don't want to provide coverage that they don't want in terms of someone's, let's say someone makes a scandalous accusation of criminal act, but the fund says, okay, we're going to defend you. But then at some point they say, no, it's no longer appropriate to defend it. In this case, it was when there was a criminal conviction, when the sentencing occurred. At that point they say, no, this is a criminal act, we're not covering it. But they have the discretion up until that point. But what the appellants are seeking to do here is to say that you can't enforce the policy as written. You can't say, I'm going to provide coverage to the sheriff and not provide coverage to the criminal actor here. And at no point have they addressed the actual language in this case. And when you say the Mason Court, the dicta Mason Court applies, but then ignore the fact that there's an exception to the exclusion, you're ignoring the very issue before the court. And the issue of self-insured versus risk management pool versus insured, that is only relevant if you get to the next step. If there's no ambiguity, if there's no issue of conflict between the provisions, there is no reason for rules of interpretation to apply. The rules of interpretation only apply when there's an ambiguity that needs to be referred to rules of construction for its interpretation. Here there's no ambiguity. But let's say you have an ambiguity, you go to rules of interpretation. The rules of construction applicable to insurers and why they're so adverse to insurance companies is not because it's called insurance. It's not because of what the label is. It is because of the nature of the relationship between an insurance company and an insured. You have a sophisticated entity that issues policies, they write, they interpret, and they issue to lay people who have no understanding of the issues in many cases. It is the disparity of bargaining position and understanding and the handling of the claims process that forces insurers to be subject to rules of construction in a contract situation that are adverse to them.
Yeah, here we don't have, the insured's not here today.
No, but in
Right.
terms of the rules of construction for
I know,
an agreement, the
but the-
sheriffs decided what they wanted to provide. They decided what they didn't want to cover, they decided how they wanted to interpret it, they decided how the dispute resolution on a coverage issue should be determined.
My only point in asking the question is, this is what happens when you have someone that's not a party to the insurance contract seeking a declaratory judgment, challenging the meaning of the contract, right?
Well, certainly they'll have the motivation, and we can't force Sasser to appear. We obviously served him, we obviously tried to bring him in. Sasser also didn't make use of the process set forth in the agreement that allows him to challenge the coverage determination. When the denial letter was issued, he didn't respond, he didn't say, hey, I challenge this, I would like to have a reconsideration before the board and have them reconsider the position of withdrawing the coverage.
Did Volt go through the process?
No, and I don't know technically whether they would have the rights, because it is covered members and the individuals.
Well,
are
sure,
subject
but
to it.
Volt, presumably, the only theory that she would have for being here at all is that she steps in the shoes of an insured as a third-party beneficiary, which is what the Supreme Court originally said, that they cited and has been abrogated. But
And
why would a third-party beneficiary not have to go through the same process that an actual insured would have to go through to challenge the terms or coverage of a policy?
like I said, one of our arguments is that the determination process and interpretation rules and procedures for challenging that is a secondary basis for the court to interpret it. And apply and say, this is what the fund has decided it means, and therefore I don't want to say it removes the jurisdiction of the court, but the court can say, because the process has been followed by the fund and this is the determination, it should be upheld. And it wasn't challenged in the manner in which the trust agreement provides the method for challenging it, meaning go to the board, say, I disagree with your determination, I want a hearing or issue before that. That wasn't followed, so it's a secondary argument for why it should be enforced. And I get the issue of, the appellant really doesn't have a role here. But again, we would also argue this isn't insurance necessarily, but Busey was also a very unique case. The Supreme Court basically said, hey, we're gonna treat motor vehicle liability insurance as a public policy issue, and therefore, for this particular type of contract of insurance, we are going to treat people as third-party beneficiaries. It had never been done with anything else, and obviously the subsequent case law is withdrawn from that. So, again, I understand the court's concerned about the standing of the appellant, but I would say with respect to the interpretation of the policy, the Florida law, even if you said this is an insurer, even if you applied the harsh rules of construction, the case law is abundantly clear that providing coverage of any type, no matter how limited, is going to defeat an argument of ambiguity and illusory coverage. And here we have a substantial coverage provided to the sheriff, and he's being defended in this case for the criminal acts of Sasser. It defeats the entire argument that there is no coverage for this. I see my time has expired. Thank you, Your Honor.
Thank you. Rebuttal.
Your Honors, a finding of illusory coverage is a high bar in this state, and that is true. That is true, it's a high bar, but I have not found a Florida case that lets an insurer avoid coverage for an employee simply because the policy preserves the employer's vicarious liability.
What's the harm that your client suffers at the hands of this judgment that's on appeal? Like, how is your client harmed
We can't-
presently by this judgment being in place?
Your Honor, our defendant is represented by a pro bono lawyer who is appearing unpaid and just enough so that whenever Mr. Sasser, and this is my understanding of it too, I'm not working in the federal court, in the case in the federal court below, but the hardest thing in the world to do is litigate a case against a pro bono defendant. I don't know if any of you ever had to do it, but if you've got a pro bono defendant, you're begging him the whole time to go and find a lawyer. I've done it a couple of times, and you just need that lawyer over there to advise the person so that the case can proceed. It's just.
Is there a case from the Supreme Court ever in the history of the state that has said that the absence of a paid lawyer on the other side is harm that is cognizable to support an appeal?
Certainly not, Your Honor, certainly not. I mean, I haven't looked for that case, but certainly not. But the point being that, same as with the Busey case, the reason the court said that was so that it was for the economy of justice, so that justice can proceed, so that the litigation can proceed. And that was the common law until abrogated. That was the common law of the state of Florida until abrogated by statute. And the abrogation should be strictly construed. Now, I understand that the Supreme Court has expanded that, but it's still an abrogation of the common law. And the common law is, my understanding has always been that the common law does recognize that a person who is, that a plaintiff would have an interest in being able to recover from a defendant who is being, against whom a case has been asserted, against whom a claim has been asserted. I said justice denied and justice delayed, but there is also justice unenforceable. And that's what we're looking at right here as against Mr. Sasser, is the possibility of unenforceable justice. And that's why we're here. That's why we're here, and we're asking. That's why we're asking this court to grant to interpret this contract, recognize that as to Mr. Sasser, coverage is illusory. And that because it is illusory, the policy should be interpreted to favor coverage under the rules of construing an insurance policy, or even under the rules of construing a contract in general. If we say this is not an insurance policy, under the rules of construing a contract in general, the ambiguity should be construed against the insurer and in favor of coverage for Mr. Sasser. No further questions, Your Honor. That's it. I saved y'all 30 minutes. 30
Thank you.
seconds.
We appreciate it. Thank you both for your argument. We are going to stay on the bench while counsel switches for the next case.